Some introductory notes on our study of trademark. As it was with copyright, our focus is going to be a potential defendant's attitude towards trademark. Businesses do also have their own affirmative trademark interest to think about, but that won't be our focus. My perspective is that trademark infringement is simply a kind of false advertising about source or sponsorship. Here is why you should be wary of my perspective. Despite the structural similarity between infringement and other types of false advertising claims, it's a lot easier to win a trademark case than another false advertising claim. Key reasons. Trademark law lacks the commercial advertising or promotion limitation that the Lanham Act has. Trademark law lacks a materiality requirement, so you don't have to show that the consumer's false belief affected their decisions. Also, there's no requirement of consumer survey evidence, even if the alleged association or sponsorship is only implied rather than stated outright. And trademark also lacks the limits that substitute for those limits when it comes to defamation law. Trademark law does not have a scienter requirement. It also doesn't have damages proof requirements. Indeed, courts are often quite willing to presume damages and perhaps more willing to award disgorgement than they are for false advertising. Actually, there's no perhaps about it. Even before the Supreme Court's recent decisions, courts were hesitant about damages in false advertising cases and disgorgement in false advertising cases, and very happy to award disgorgement in trademark cases. This is not to say that trademark plaintiffs always win, but trademark has carved off enough of an independent existence for itself, something we'll see most clearly when we discuss trademark dilution, that as a lawyer, you have to think differently about some aspects of a trademark case than any other advertising case. Nonetheless, and coming back to why I hold the perspective I do, you see in trademark the justifications for advertising law generally. So we're interested in providing good information to consumers. We're interested in protecting consumers in their free decisions without deception from the seller. We want to encourage advertisers to invest in quality instead of participating in the market for lemons. So given the justifications for trademark law and how well they map onto the justifications for regulating advertising in general, if you're suspicious that government regulation of advertising is necessary because you think consumers can generally take care of themselves, arguably you should not make an exception for trademark. Contrariwise, if you worry that consumers are easily deceived, you might think that strong trademarks are important and courts should readily intervene to protect trademarks. But perhaps oddly, these views rarely travel together. Instead, we tend to get people who believe in strong trademark rights and weak advertising regulation, or vice versa, like me. I, of course, think I'm completely consistent and I can defend my position. Rather than treating consumers as generally bad at processing ads or generally good at processing ads, it's more accurate to say we have strengths and weaknesses. In 21st century America, our strengths are often about brand evaluation, meaning we're probably better at identifying source than at evaluating many other claims in ads. The way we perceive search engine advertising is a good example. Most people cannot reliably tell organic results from sponsored results, but they can usually tell whether the advertiser whose trademark they searched for is associated with a particular link on the results page. So different kinds of sophistication. Lillian Bevere, whose work we encountered early in the course, is on the opposite pole. She thinks advertising is basically all puffery. That being the case, the only value worth protecting in ads is the puffery. So when an advertiser succeeds in giving you warm and fuzzy feelings, it should be able to appropriate that reaction as its property. Thus, she supports strong trademark rights and limited protection against false advertising. She also does say that consumers can't protect themselves against counterfeiting the way they can protect themselves against other possibly false factual claims. They can't protect themselves with skepticism. That's just illogical. There are plenty of things you can do to avoid counterfeits in many circumstances, including by buying only from the official sources and not buying on Amazon or eBay. And also, protecting oneself against counterfeiting is not particularly relevant to what turns out to be the scope of trademark rights. As you'll see, trademark law provides rights far beyond the scope of anti-counterfeiting protection. So just a brief recap of the mechanics. Rights in the United States to trademarks come from use. The registration with the Federal Patent and Trademark Office, known as the PTO, confers various benefits. People adopting trademarks, whether they be in the form of product names, Slogans, designs, or other forms of source identification are well advised to do a trademark search. There are various specialized firms that do this. Some marks are protected against dilution, but all valid marks are protected against confusion. So that's where we'll start. We'll look at the test for likely confusion through the prism of internet cases. Internet advertising raises special concerns when it comes to trademark for several reasons. First, from a defense or ad review perspective, you need to make sure online initiatives go through a review process. Online advertising or online activities are often handed off to a separate person with minimal oversight from marketing. You build a website or you build a presence on this app, that's given priority and compliance will take a back seat. The process will be repeated with each new service. Facebook, Twitter, Yelp, Foursquare, now let's get the intern to do TikTok. The lawyer needs to be part of it or it's going to end in tears. Second, online developments heighten the salience of trademark. Courts expanded the concept of infringement and began to accept dilution, broadening the rights conferred by trademark. And then it turns out that you often need to rely on your competitors' marks to be where you need to be in front of the consumer. When searches are dynamic and results are generated in response to each user's request, then the advertiser needs some mechanism for showing people that they have a competing offering. And that generally requires some way of using the competitor's mark. Finally, trademark law developed online will also affect offline advertising and vice versa. Initial interest confusion is an example of a doctrine that is now important both online and off. So that's the introduction, and I will see you in class. Thanks.